with y'all today. What I hope to do over the next few minutes is to explain sort of the genesis of the religious freedom legislation that we have been working on these last several years, why I believe it is important, and also talk about a couple of other religious freedom related issues that are not directly addressed by RFRA. So to begin with, I like to kind of pull back and give some historical context before getting into the specifics of this debate. The idea of religious freedom is not a new concept. It was not even a new concept when the founders wrote the protection of free exercise into our Constitution in 1789. The founders understood, because many of them had come through the English system, the historic protection of religious freedom that actually goes all the way back to 1215. When the Magna Carta was signed by King John, the first protection was that the crown would not in any way molest or prevent the church from being able to carry out its duties. And so we have an 800-year tradition of understanding that the government should not interfere with our ability to practice our faith the way we see fit. Now, in the American experience, the First Amendment to our Constitution protects 4 freedoms. You have the free press, free association, free speech, and free exercise of religion. And that phrase is very, very important. It's not freedom to worship. It's not freedom of religion. It is free exercise of religion. And the founders used that phrase for a very specific reason. They understood, having come from a European continent that had been beset by conflicts over religious faith for centuries, that people don't just, your faith is not just something you do on a Sunday morning. It is something that animates your life. It is not like a suit of clothes that you put on and take off at your leisure. And so free exercise of religion has a very specific meaning, and that means not just where I go to church or where I worship, but the choices that I make in my daily life, whether that's in my career, in my profession, at home, whether it's educational choices I'm making, all of those things, to a greater or lesser degree, get animated by one's faith. And so the founders understood that. Well, for most of American history, all the freedoms of the First Amendment enjoyed a protection known as strict scrutiny. And I'm not going to try to get too down in the weeds on legalese, but this is important to understanding the debate. If you think about it, no right is absolute. For example, when we talk about free speech, you're certainly able to speak freely, but there are limitations on it. If you think about the famous Supreme Court case where they talk about yelling fire in a crowded theater, right? Well, yes, you have a freedom to speak, but that freedom to speak, when it butts up against the public interest, in that case, the possibility of creating a stampede and endangering other people, there are limitations on that right of free speech. So courts have had to figure out, how do we balance that? How do we balance the public interest against one's individual civil liberty? And so for most of our history, the courts applied something called a strict scrutiny test. When you think about this, I think about it as rungs on a ladder, okay? Strict scrutiny would be at the very top of the ladder. So if the government is going to do something that abridges one of these 4 fundamental freedoms under strict scrutiny analysis, they have to show 2 things. They have to show that there is a compelling state interest that is involved. It can't just be any reason. It has to be a compelling reason. When you think about free press and limiting the publication of troop movements, okay, there's a compelling state interest there, right? It's national security. It's the safety of our troops that are in harm's way. And then the second part of that test is it the least restrictive, means available. Is this the least restrictive way of achieving that government interest? And the best way I know to illustrate that for you is to tell you a little bit about the Hobby Lobby decision. I'm sure many of you followed that in the news several years ago. The Hobby Lobby case was simply this. The federal government had passed and was implementing the Affordable Care Act. Some folks refer to it as Obamacare. In that legislation, there was a mandate that employers had to provide a range of contraception options, including drugs that induce, under certain circumstances, induce abortions. The Green family, who owns Hobby Lobby, it's not a publicly traded company, it's a family-owned, privately held business. They said, we're willing to provide these 9 other forms of contraception, but we're not willing to pay for drugs that will induce abortions because that is offensive to our religious faith. From our religious point of view, that is being a party to and a financier of a murder of an unborn child. We're not going to do that. And so they went to the Supreme Court, and here's what the Supreme Court found. They didn't get to the question of was this provision advancing a compelling government interest, but what they said was, you've already provided, federal government, you've already provided an accommodation for religious employers. Because the Obama administration had already said that churches and other explicitly religious employers didn't have to follow the contraception mandate. And so they said, you've already conceded there's a less restrictive way of achieving the interest by giving these folks an accommodation over here. And so that's why Hobby Lobby prevailed. So that's what the strict scrutiny test is. You got to have a compelling state interest. You got to show it's the least restrictive means available. For most of American history, that's how all 4 of these freedoms were litigated in court, if the court was trying to decide who wins out, the individual or the public interest. Well, in 1990, there was a United States Supreme Court decision called Employment Division versus Smith. And in that Supreme Court case, what the court said was, we've been wrong about free exercise cases. Strict scrutiny is too high of a standard. The facts of those cases, just so you know, it involved a Native American tribe and the use of peyote in a religious ritual. And the government was seeking to criminally prosecute those who were possessing and using peyote in the religious ritual. And the Supreme Court in that case, finding that the government could prosecute, said, you know what, we're getting rid of the strict scrutiny test for free exercise cases and we're replacing it with something called a rational basis test. If you think back to the ladder I mentioned earlier, if strict scrutiny's on the top rung, rational basis would be the bottom rung. The government just has to give you a reason, any reason. It just has to be a rational basis of some kind, and they can overcome your free exercise protection. As you can imagine, back in 1990, this was not a right-left divide on this question. The public was outraged at the idea that the government could come in and basically dictate to these folks whether or not they could practice their faith tradition. And so Congress, and one of the few times this has happened in American history, Congress passed in 1993 the Religious Freedom Restoration Act. And so what did that do? Well, if you focus on the word restoration, all it did is it said to the Supreme Court, we want you to continue to use the strict scrutiny test that you used all the way up until 1990. We want to go back to compelling state interest and to least restrictive means available if you're going to override somebody's right of free exercise. That bill in 1993, just to give you an idea that this was not a political controversy, it was introduced in the House of Representatives by a congressman from New York named Chuck Schumer. I don't know how many of you know who Chuck Schumer is, but he's not a right-wing guy, okay? It passed the United States House of Representatives unanimously, voted affirmative by everyone in the House, including then Congressman Nathan Deal. It goes over to the United States Senate, where it was sponsored and carried by another real right-wing guy, Ted Kennedy of Massachusetts. Maybe y'all know who Ted Kennedy is. That passed in the Senate 97-3. and then it was signed into law by then President Bill Clinton. So this was not a partisan issue. It was not a divisive issue. Everybody agreed, you know what? This is important. Free exercise is important. And protecting the diversity of religious faith traditions in our country is important. So people normally ask me when I get to this stage in a conversation, because I've had this conversation many, many times with a lot of folks, they'll say, well, Josh, if the Congress passed that law, why does Georgia need a law? There's a federal law already in place. And that's a very good question. The answer to that question can be found in a 1997 Supreme Court decision called City of Bern versus Flores. In that case, which was out of Texas, the local government was taking the position, hey, Congress, you can decide what the standard is for the federal government, for cases against the federal government. But Congress does not have the authority to decide what legal standard is going to be used in my state when it comes to a free exercise claim against the state government or the local government. So it goes to the Supreme Court, and the Supreme Court agrees with the City of Bern. They say, you're right, Congress has overstepped their authority. So here's the situation that we found ourselves in a few years ago when I started down this road of trying to get this bill passed. In Georgia, if you are an inmate in a federal prison that is situated in this state and you have a claim on religious freedom, you get strict scrutiny. You get the top of the ladder, okay? But if you or I have a free exercise claim against our state government, against the county government, against a municipal government, against a school district, we get the rational basis test. So again, an inmate in a federal prison gets more protection of his religious freedom than you or I do from the state or local government. To me, that simply did not make any sense. It seemed to me that there should be a uniform legal standard, and that legal standard should err on the side of more protection of religious freedom, not less. Now, people will ask all the time, well, Josh, you live in Georgia. It's the buckle of the Bible Belt down there. Y'all don't have these problems with, people coming in and trying to interfere with folks' religious freedom. Well, I just want to give y'all a couple of examples to illustrate that is simply not the case. The first one I'll mention to you is, and this is what got me searching for sort of a global solution to these issues. It seemed like every year in the General Assembly, we were dealing with a bill on religious freedom of one kind or another. In 2013, a colleague of mine from Carrollton named Mike Dugan introduced a bill that we called the Merry Christmas Bill. And this came out of an incident that was occurring down in Bullock County in the Statesboro school system, where they were actually warning teachers against wishing kids a Merry Christmas as they were approaching the end of the fall semester. Teachers were fearful that their careers were going to be negatively impacted by saying to a kid, Merry Christmas. That to me seemed so ridiculous. I mean, and we passed that bill. We went through the legislature, the governor signed the bill, but the idea that it literally was going to require an act of the General Assembly for K through 12 teachers to feel safe saying Merry Christmas or Happy Hanukkah at Christmas time, and we had this whole wordsmithing thing in the bill about defining what traditional winter holiday greetings were that were, allowed. So I was looking for a more global solution to this. There were other cases that I came across over at Savannah State University, and most of the problems, most of the cases that concern me are in the educational context. And the reason they concern me is when someone is going through their formative years, whether they're in a K through 12 school or they're away from home, away from their parents, away from their home church for the first time in a college or university environment, we don't need the state to be trying to squelch their free exercise. At Savannah State University, what happened, there was a Christian student organization on campus. They held a discipleship retreat. As part of the discipleship retreat, they had a foot washing ceremony. A university bureaucrat at Savannah State said that having the foot washing ceremony violated Savannah State's anti-hazing policy. And I mean, it's laughable. Every time I tell people that, that is the reaction. But for 3.5 years, that case got litigated before the university finally threw in the towel and ended the dispute. People will then often say, when I give these kinds of examples, well, see, Josh, everything worked out fine. All they had to do was hire a lawyer and spend 3.5 years fighting in court, and then they were able to practice their faith the way they chose. That is not a good outcome. That is not a good sign about the state of the current law in our state. More recently, this is just in the last year, and the folks on the other side of the debate don't like talking about this because this involves a young woman of the Muslim faith. But there was a young woman who she was dressing modestly. She had a face covering, and she came to class at Georgia State University for a lecture. The lecture ends. The professor asks her to come down after the lecture. He tells her that if she comes back dressed that way again, not only is that unacceptable as far as he's concerned, but that he is going to see that she is prosecuted under Georgia's anti-mask law. The anti-mask law, for those of you not familiar with it, is something that was passed at the sort of the height of the Klan, that people were covering their faces and then committing criminal acts or covering their faces to intimidate people. The idea that in 2017 that a young woman at a university is being told, again, away from home from the first time, is being told, not only is your faith tradition wrong, and not only is it unacceptable in my classroom, but I'm going to go see somebody about having you criminally prosecuted for it. That is a very chilling environment for people of faith to be operating in. There was a child at Sutton Middle School in the Atlanta public school system who wanted to be able to read the Bible with other students after school. He just wanted to use a classroom to do that. And the Atlanta public school system said, no, you can't do that. We're not going to allow that. The parents got involved. They threatened litigation. And eventually the school system said, well, you can do it as long as you pay rent for the use of the classroom. Now, I can assure you, and this is kind of part of to me, the overarching theme here, if the Free Thought Society or the Atheist Society wants to use the classroom, there's not going to be a fee being charged. There's not going to be all this pushback, because what's really happening is that the state, which the founders understood, the state's role was not to promote any particular religion. The state's role was to be an independent referee and to basically protect every faith tradition. But what we've seen now with some of the pressure groups that are sort of militantly, secularly atheistic, is they want the government to put their thumb on the scale in a way that will promote atheism, that will promote non-religion over any other faith tradition. And that is just as offensive as if you had a state government or a federal government or a local government promoting a particular faith tradition. It's equally wrong. So we've seen all of these cases. Over in Villa Rica, there was a football coach, an assistant football coach, who was on the faculty there, and he had decided he wanted to become baptized. The football field was a very important place to him, and so he went to the principal of the school and said, look, we would like to, on a Sunday, when nothing is happening at school, where no students are mandated to be on the campus, I would like to be able to be baptized on the football field. And the principal signed off on it. They said it's fine. The appointed day comes. They have the baptism. Some students showed up. Some students that attended the same church as this fellow show up. The Freedom from Religion Foundation up in Wisconsin sends off this letter and threatens a lawsuit, and the school district winds up adopting a policy essentially barring people of faith from using these taxpayer-funded facilities that are supposed to belong to all of us. The last one I'll give you, because I could be here until the sun goes down giving you these examples. But the last one I want to give you involves a place not far from here. At Georgia Gwinnett College, a young man wanted to be able to engage in open-air preaching. He wanted to be able to evangelize and share his faith with his fellow students. So he goes through the process that is required today at our universities of filing all the appropriate forms so that he can be granted permission to speak in the designated free speech zone. So he does all of this stuff. The appointed day and time comes. He and a friend of his arrive at the free speech zone. He begins to preach. His friend is passing out religious literature to those who are interested. Within 15 minutes of him commencing his speech, the campus police approach him, say, "You're disturbing these students over here. You're going to have to stop." Now, I want you to think about this for a moment. University campuses, if there's any place where a free exchange of ideas should be allowed to occur, I think it would be on a public college or university campus. And here's an individual, an exchange student actually from another country, by the way, who comes to America, who's at a public college or university. He fills out all the paperwork, he gets the university to approve it, and then he's confronted by armed police and told, "You've got to stop. You cannot share the message you want to share." When he goes to complain, he's told, "Your message is not welcome at Georgia Gwinnett College." That case is being litigated right now. The state of Georgia, in the brief, trying to have the case dismissed, says, all we need is a rational basis to silence him and shut him down. So if he was making this student uncomfortable over here, that is sufficient because we have a reason. So when people ask you, well, why does it really matter if we pass this bill or not? It's cases like that. Because, and the reason this issue is important to me is my own sort of faith journey really began in earnest with a discussion in a college classroom. That I think if this sort of thing was going on, I'm not sure that the student who engaged me in that discussion would have felt comfortable even having that discussion with me. So it's important. It's important not just because of the cases that I can tell you about today. It's important because of all of the cases of people who get chilled. Think about an 18 or 19-year-old who is told by an authority figure what you're doing is wrong. How many of those people are going to think, "No, you're wrong, and I'm going to go get a lawyer"? You know, I mean, a lot of religious activity is being chilled before it even begins because people don't feel that it's going to be permitted or that they're going to be in some sort of legal trouble. So that's why this legislation is important. So what does the legislation do at the state level? All it does, it is a mirror image of the legislation that passed in 1993. All we are saying is we want, if we're dealing with the state government or the local government in any capacity, if they want to challenge your right of free exercise, they better be able to show there's a compelling interest and it's the least restrictive way of achieving that interest. That's all we're trying to accomplish. So what does the bill not do? There's been a lot of discussion about these wedding vendors, okay? Somebody that's a florist or a baker or a photographer who doesn't want to participate in a same-sex wedding. This legislation, I just want to underline this for you. This legislation does not impact that one way or another, okay? This legislation specifically is talking about the types of cases that I'm referring to. Now, in Georgia, most of the state, there is no non-discrimination law that deals with sexual orientation. So it's not really an issue. For example, if in Loganville, I don't believe the city of Loganville has an ordinance on this, if a wedding vendor wants to only be involved with weddings at the Anglican church and the Catholic church or so on, they can do that. They have every right to do that. The only place where this comes into conflict is where you have either state or local laws that are saying there's no discrimination based on sexual orientation. Now, the city of Atlanta has an ordinance like that. I believe Athens, Clarke County has an ordinance like that. But I'm going to tell you, in the litigation around the country, when that issue has come up, New Mexico is probably the most famous case, a case called Elaine Photography. And it was a wedding photographer who did not want to photograph a same-sex wedding. That went all the way to the New Mexico Court of Appeals, and they had a statewide non-discrimination law. And what the court found was, well, the government's identified a compelling interest. That compelling interest is preventing discrimination on the basis of sexual orientation. And this is the least restrictive means of accomplishing that. And so Elaine Photography lost under the Religious Freedom Restoration Act. In Kentucky, a lot of people probably remember the Kim Davis case. This was the county clerk, did not want to issue the marriage licenses. Kentucky has a state RFRA law. Kim Davis went to federal court and said, RFRA, I don't have to issue these marriage licenses. And the court said, no, that's not true. You have a legal duty to issue the licenses in your capacity as a county clerk. So I bracket that for you to say that issue is an issue that I think is going to continue to be debated and discussed, but it is a lie. It is a falsehood being peddled by folks on the other side of this debate to say that this bill that we have been trying to pass for the last 3 or 4 years would have any impact on those type of cases. What this bill would have an impact on is it would have an impact on when the government's trying to prevent a church from locating somewhere over zoning pretext. It would prevent the government from coming in, as has happened in many municipalities, where the government tries to actually enact a citywide ban on feeding the homeless. That has been litigated under RFRA, and the church has won on that. In the education context, making sure students are free to share their faith and practice their faith. So those are the kinds of cases that RFRA really impacts. Now, the other kind of case that I think people need to be aware of, and something that needs to happen in Georgia to truly protect religious freedom, has to do with something called the Blaine Amendment. We have an amendment to our Constitution. It's named for a senator from the state of Maine. And he tried to have the federal Constitution amended with this language that basically says no state revenue can flow to a faith-based organization. And this is being litigated all the time. I don't know how many of you are familiar with the Student Scholarship Organization Program under Georgia law. It's where you can direct some of your state income tax dollars to private K through 12 schools. Well, that just went to the Supreme Court on a challenge that faith-based schools shouldn't be able to benefit from that program. Now, the Supreme Court turned that down on some other grounds, but what we're continuing to see is this steady drumbeat of trying to prevent faith-based institutions from having any kind of support from the government. I mean, one of the things we've talked about is in the area of educational choice would be to provide every family in the state with a debit card that's loaded with the funds that the state expends on your children's education. And then you can make the decision, if you want to send them to a school that is going to teach them your faith tradition and help support what they're learning at church and at home. With the Blaine Amendment in place, it will be very difficult for us to ever do that. When you think about, we passed a law a couple of years ago, which I think is going to be challenged, having to do with directing state Medicaid dollars away from Planned Parenthood and towards pregnancy centers, crisis pregnancy centers. There is a very real possibility that's going to be challenged because of the Blaine Amendment. So in the state Senate, we have tried several times to repeal the Blaine Amendment. It would require going on the ballot. We've passed it in the Senate. It has stalled in the House. But I tell all of you this to say there is a real fight going on about the level of protection of your religious freedom. It is not an abstract academic legal argument. It is very real, and it is something that we're seeing more of every day. And I want to close by telling you a little bit about the debate we had on the Religious Freedom Bill and a colloquy I had with one of my colleagues in the Senate. And then hopefully, if you've got some questions, I'd love to entertain any questions that you might have. But I asked this colleague of mine, I said, do you agree that a church or a faith tradition has a right to a teaching on marriage? She said, well, yes. Yes, they do. I said, well, let's just say, because she had spent all this time talking about how we're trying to legalize discrimination. I said, if that church were to teach that marriage is a sacrament and that it is only between one man and one woman, would you say that deserves the protection of the law? And she kind of gave me this, she did not say yes. So then I said, well, let me ask you this question. Should a church that teaches that receive the benefit of a tax exemption as a charitable organization? And she said, well, I think we're going to get to a consensus in about 10 or 15 years that no, we'll take the tax exemption away from churches that teach that. And I said, well, what about a religious school that in the theology class teaches that? Should they be accredited? Should their diplomas be, valued by higher institutions of higher education? Well, no. I mean, I think we should probably take the accreditation away from church-based educational institutions that teach that. So when you think about the consequence, and I use that as an example, but we could talk about a lot of different doctrines that different faith traditions have. The fundamental question is, whatever you believe about these ideas, do people have the right to entertain these ideas and to live their lives according to their faith tradition? Or are we going to start having a country and a state where the government says, okay, everything on column A is okay. As long as your faith tradition falls into column A, we're not going to punish you. But if you've got any of these column B ideas, it's going to get pretty difficult for you. We're going to start charging you property tax, which is something the mayor of Atlanta's talked about. We're going to talk about taking away the accreditation of your educational institution. We're going to talk about taking away your tax-exempt status. That is where this is ultimately heading. I mean, it is very clear to me from the people on the other side of the debate. And so when people say, why do you bring this back year after year? Why did y'all reintroduce it after Governor Deal vetoed it? Because the moment that people of faith concede on this ground, in my opinion, that debate is lost. We're either going to agree or disagree. And it's strange to me because we don't have that debate about free speech. We don't have that debate about the free press. We don't say, well, you put some stuff in that newspaper that I don't like, so, we're probably going to charge you some extra taxes, or we're probably going to, take away your business license. We wouldn't even, there wouldn't be a serious discussion about that. But for some reason, because we're talking about religious faith, and there are people who the end game for them is for the government to be an unapologetic exponent of a sort of militant brand of secular atheism. That is the end game. So that's why this debate is so important to me. It's why I would want to be here with all of you this morning talking about this issue, because it takes all of us educating other people and for them to understand what this is about. This is about protecting a foundational principle of a free society. I can't stand, I don't know how many of you are familiar with the Westboro Baptist Church, but this is the group that protests the military funerals, and they use some terrible, abominable language, okay? But I don't want to live in a country where they're going to be outlawed, okay? Because if the government can outlaw that, the government can outlaw anything that a group of people find offensive. And what somebody finds offensive today and what somebody finds offensive tomorrow can be two very, very different things. So that's why this is important to me. I think it's why it should be important to you. I appreciate y'all listening to me. I tell people all the time it's dangerous to give a lawyer a microphone and a captive audience. So I appreciate your indulgence as I've gone through all of this. But I'd love to answer any questions if there are any. Yes, sir.
Actually, I've got two questions. The first one is the Religious Freedom Restoration Act, the federal law. What would protect Reverend Henry's rights that the Religious Freedom Restoration Act does not do?
Sure.
My second question, I'll just go ahead.
Yes, sir.
The same things, part of free exercise. My second question is, your bill would not protect my right as a baker or a florist or whatever to refuse to do work that would, with flowers or cakes or whatever, support same-sex marriage. And I got pretty strong feelings about that. Pardon me, folks, because I'm Lutheran, and Martin Luther said every Christian had a calling, and all callings were equal. And if I'm a baker and I have to bake a cake to support a queer wedding, that's a violation of my calling from God, because Christ is in me, or so it was said during Holy Week, John chapter 14. And if Christ is in me, how can you make Christ support a queer wedding? So anyways, two questions.
Sure.
What would your bill do to protect Henry? And why doesn't your bill protect me?
Yes, sir.
As a layman?
Yes, sir. Absolutely. So when it comes to the difference between the Federal Religious Freedom Restoration Act and what we're trying to do, if the federal government, if you're having some dispute with the federal government's trying in some way to infringe on the free exercise that is taking place at this church, Federal Religious Freedom Restoration Act protects you. If you go to court, that you can force the government to say, hey, government, you're going to have to show this judge that there's a compelling reason you're doing this and that it's the least restrictive means to accomplish it. If it's the same situation, let's just say y'all wanted to open a soup kitchen and the Gwinnett County or Walton County Commission said, no, we're not going to let you do that. We think it's going to attract the wrong kind of folks to this part of town, so we're denying it. You don't have the protection of the Federal Religious Freedom Restoration Act. They just have to give a reason. For example, if you had a ministry to feed the homeless and the county adopted a countywide ordinance saying, you know what, we think it's unsanitary and we think it's a danger to public health to allow private entities to engage in a ministry feeding the homeless, all they have to do is articulate that reason. It's unsanitary. It's a danger to public health. Boom, end of conversation. Okay? They're going to win on a free exercise case in Georgia today in 2017. If we pass the bill I've been talking about, you get the same protection in that instance that you do dealing with the federal government. So what we're trying to do is to extend the protection that exists when you're dealing with the feds to dealing with state and local government. That's the answer to your first question. Now the second question, and I want to be real clear about this. As an attorney, there's been a model code of ethics put out by the American Bar Association that says that if I participated in a continuing legal education debate on the pros and cons of same-sex marriage or whether or not there should be a law protecting against transgender discrimination, and I took the con position that I could be subject to bar discipline for saying that. So I am very concerned about the issue you're talking about the wedding vendors and all of that. What I'm trying to make clear to you is that when we talk about religious freedom, there's not a silver bullet bill. There's not one bill that's going to solve all of these problems. The Religious Freedom Restoration Act solves a great deal of the problems, but all of these issues that have been created by the United States Supreme Court, and this is very similar to what happened in Roe versus Wade, okay? Instead of allowing states to work out this debate over marriage and each state sort of developing its own answer, the U.S. Supreme Court reached into the Constitution and said, you know, we've said that family law is the province of states for 220 years, but today we are changing that. And today we are saying that there is a constitutional fundamental right to marriage, and it's enjoyed equally between opposite sex and same-sex couples. That has created a host of legal questions that we're going to be wrestling with for a very long time. So the state legislature, the federal legislature, and the Supreme Court are going to have to deal with that. There's a Supreme Court case that is being heard in October, and it is one of these wedding vendor cases. It is a cake baker I think he's out of Colorado. But that decision may resolve this issue. It may just make it worse. But what I wanted to be clear in talking to y'all about today is I did not want y'all to leave here with the understanding, because of the misinformation that's been put out there, that the Religious Freedom Restoration Act is going to address this issue about wedding vendors. That's going to require separate legislation. And the example I would give is Georgia has a conscience protection in our statutory law for pharmacists on prescribing RU-486 or abortion-inducing drugs. Georgia pharmacists can't be compelled to do that because we have written into the law a conscience protection. That is the sort of thing that will probably have to happen absent a Supreme Court decision or something else to address that issue. So don't misunderstand me. I'm not saying that's not an issue that has to be dealt with. I just wanted to be clear that there's not one bill that's going to solve all these issues, just like with the Blaine Amendment and our issues in terms of government funding for faith-based educational or healthcare entities.
Simple question. Under current Georgia law, if Henry refuses to perform a gay marriage, what happens to his licensure?
So under current law, it's pretty clear to me that there's no court in the nation that would sanction any clergyman for refusing to conduct any religious ceremony that conflicts with their faith tradition. So he's not going to be compelled by any court, state court or federal court, to conduct a wedding that is outside the boundaries, and not just, frankly, a same-sex wedding. I mean, if he counsels a couple and has concerns and objections, I mean, he's not going to be compelled to do that.
Now, how does that become a scenario that protects Henry but does not protect the baker?
So what I want to be real clear about is the distinction made in the law is this. If you're conducting a religious ceremony and you are squarely in the church silo, the law.
Does it have to be on the property?
Well, no. I'm sorry, I didn't mean it that way. I meant sort of a strictly religious function, right? I mean, he's there to solemnify the marriage. That's what he's there to do. The argument that's being made, the legal argument that's being made, is that the baker or the photographer or so on, that person is out in the law that's used as public accommodation. They're out in the.
What happened to the pharmacists?
Well, that's my point, is that the state legislature passed a specific protection for the pharmacists. There's a bill that's been written and passed into law to protect the pharmacists. There's not been that kind of legislation. Now, there's legislation pending. There's a First Amendment Defense Act at the congressional level that says no person should be penalized by the government in their business operation based on their sincerely held religious beliefs. So there are proposals being put forward to solve this problem. I don't want to leave anybody with the impression that folks are just saying, all we need is RFRA. Kind of my point was that I was trying to make today is it's not just about RFRA. You've got these other components to this issue. So I'm not saying that the law as it stands today is correct in that the clergyman standing in a religious role is protected, but the person who's doing some sort of business who wants to live out their faith and who wants to make sure that their actions are in conformity with their faith tradition is not protected. But that's the facts today. So the only way to address that is to see, I would prefer to see it at the federal level because it would protect everywhere, but the state legislature needs to do it. what I would say is a little bit of a challenge to all of us is that if we can't get the governor of the state to sign a law that gives these general protections in the cases that I mentioned earlier, I mean, it's hard to even get to the threshold of talking about these other issues. And so that's why it's really important for people to be talking about it and for people to know that that's the state of the law right now. Now, the last thing I'll say about this, and I want to be real clear about it, outside of these municipalities that have adopted these anti-discrimination ordinances, no one is going to be compelled. You know, so if you're in Vidalia or Columbus or Loganville and you say, hey, I'm only photograph these weddings, I don't photograph those weddings, you're not going to have a problem. But the issue is, what about tomorrow? What happens tomorrow? What happens when the city council does adopt one of those ordinances, or what happens when the state passes a wide-ranging new law that mandates those kinds of things? So it's a question that's in flux right now. Yes, sir.
Why did the governor veto it? Was he expecting a North Carolina kind of situation?
Yeah, so that's a great question. It's very clear to me. Governor Deal was under enormous pressure from some very large businesses, and this is a good point to flesh out a little bit. The businesses take the position, business will leave Georgia, no business will come to Georgia if you pass a Religious Freedom Restoration Act. Well, let me make clear something that I failed to tell you earlier. 31 other states have passed the bill that we're trying to pass in Georgia. Florida, Texas. I had a discussion with a lobbyist with General Electric. General Electric was talking about moving their corporate headquarters. And their corporate headquarters had been in Connecticut. And I think there were 3 or 4 finalists, and Atlanta was one of the finalists. He said, Josh, I just don't understand why you're pushing this RFRA bill. You know, why do you need it? GE may not come down here if you pass RFRA. I said, oh, really? How long have you been in Connecticut? And he told me. And I said, well, Connecticut's had RFRA since 1993. You know, they were one of the first states in the nation to pass this legislation. If you talk about the Super Bowl, that's the other thing they love to talk about. Oh, we'll never have the Super Bowl again. The Super Bowl, I think, was in Glendale, Arizona last year, which is a RFRA state. The year before that, I think it was in Dallas, Texas, which is a RFRA state. The year before that, I think it was in New Orleans, Louisiana, which does not only have a RFRA, Governor Jindal signed an executive order providing protections to the wedding vendors and that sort of thing. So the idea that these businesses aren't going to do business is simply not borne out. North Carolina, which passed, and this is another big confusion that people get into, people call the North Carolina bill a religious freedom bill. Well, no, it wasn't a religious freedom bill. It was a bill saying, a very radical idea, that at public schools, that the boys should be in the boys' locker room and the girls should be in the girls' locker room. That's what that bill said. Very controversial. But if you look at the year after the bill passed, North Carolina had a record tourism year. They had a record year of bringing in new businesses and corporate headquarters. So this is a smokescreen that's put on by people on the other side, which is why, and I don't want to get overtly political with y'all, but we all have to be very discerning. Governor Deal is serving his last term. Next year will be his last year. There will be an opportunity to elect someone new. And so we need to think about and try to discern who's going to stand up for what the right thing is, whether they come under some pressure or come under some criticism or not. But I would say to you, the answer to your question is, he got this pressure from people associated with poor. I even struggle to call it the business community, because when I think about the business community, I think about the folks back home who have businesses on Main Street. I don't think about multinational corporations who have very few people that run them who are from Georgia. But I mean, we're talking about a handful of people who exercised a lot of influence over Governor Deal. Yes, sir.
You spoke about that Rica case. Did you just say somebody from Wisconsin filed a lawsuit?
Right, that was threatening to.
How can that happen when we've got local governments and we've got the state here? How
So it's a great question. There are a handful of pressure groups, national pressure groups, and this is all they do, is they look for cases around the country to come in and pressure folks. You have the Freedom from Religion Foundation, which is in Madison, Wisconsin. You have the Americans United for Separation of Church and State, which is in Washington, D.C. And I find the concept about separation of church and state very interesting. They only want it one way, you know. I'm all for the government being separated from my faith tradition. You know, I don't want the government to interfere with my ability to practice my faith the way I see fit. But it's that group and groups like that that will come in, and the way they come in is they find someone locally. So they'll call around and they'll locate somebody who agrees with their agenda, and then they'll say, look, we've got all this financial backing, we'll hire the lawyers, we'll do everything else for you. And then the calculus, particularly when you're dealing with local government, is, oh man, you know, this is taxpayers' money, we don't want to be engaged in some multi-million-dollar litigation, we just need to give in. And so that's what winds up happening, and that's what happened in the Villa-Rica case. It also happened up at Chestatee High School in Hall County. They had a playbook, a football playbook, with inspirational sayings, quotations. There's a quote from Gandhi, a quote from Martin Luther King Jr., but they also had some scripture in the playbook. And so the Freedom from Religion Foundation sent a letter to the Hall County School Board and said, those playbooks have got to be scrubbed, you know, because you're establishing a religion by having that in the playbook. And again, you know, they backed away from it and said, okay, let's sanitize all these playbooks. You know, Joe Kennedy, I don't know, this is not a Georgia case, I don't know how many of you are familiar with Coach Kennedy, but he's a coach out in Bremerton, Washington. For 7 years, he's assistant coach, beloved by the kids and everything. He would go out at the end of every football game and take a knee on the 50-yard line and say a quick prayer of thanksgiving. They got it put in a new region 2 years ago, and he goes to do this, and there's a faculty member from the other school that sees him doing that and starts complaining, starts making a big stink about it. And so the school district actually tells Coach Kennedy, well, you know what we're going to do is we're going to build you a closet up by the press box. And if you'll just go to that closet and you can say your prayer in there, just don't do it where anybody can see you. That's in litigation right now. But you know, that comes from those groups who are constantly monitoring things nationwide, because again, the end game is expelling any public expression of faith. The concept on the other side of this, going back to the free exercise versus freedom of religion, what they are looking for and what they'll tell you. I mean, I've engaged in debates with some of my legislative colleagues in various forums about this. They'll say, well, nobody's stopping you from going to church on Sunday. Nobody's stopping you from reading the Bible in your home, you know. But what they just have a different definition of what practicing your faith is. They say, you know, can't do it at work, can't do it in a public place, can't do it at a public school, can't do it at a public college or university. The only places that are permissible for now are within the four walls of the church and within the four walls of your home. And that's where these groups are pushing us toward.
Josh,
Yes, sir.
concerning the pregnancy centers, as far as protection for our people who witness to clients, if they will allow them, they say they need to, and also about, you heard in California and another state where they're being where the judges agreed that they should be forced to refer patients to abortion clinics. How do you see, I mean, does religious liberty have anything to do with that? Is that a separate thing, as you were talking about?
No,
another legislation had to be written for that?
It's another aspect of the religious freedom debate. In California, the legislature has recently passed a law mandating that crisis pregnancy centers give people a referral to an abortion facility. And so unless and until there's either a case that comes down on that, or there's some kind of federal legislation that comes down on it, at least in California, those folks are being put in a terrible position. You know, we haven't even talked about this issue about adoption agencies. That came up, and it's just sort of related. in the legislature this past year. We were going to update Georgia's adoption law. Well, even before the Supreme Court decision, in Massachusetts was one of the first states in the nation to legalize same-sex marriage at a state level. Catholic Adoption Services, which had been operating in the Boston area, for over a century, and was placing, I think, something like 10,000 at-risk youth on an annual basis, they shut down because the state said, well, now that we've changed the law, you've got to place kids wherever the state tells you. And of course, they had a practice, and a lot of faith-based adoption agencies have a practice, of they're only going to adopt out children to a married opposite-sex couple. They're not going to adopt out to single people. They're not going to adopt out to married or to two opposite-sex folks living together who aren't married. But it's a similar situation. You're talking about putting people in the position of, with a crisis pregnancy center, a referral to an abortion clinic or facilitating that process. From my way of thinking, that's no different than what was going on with the Hobby Lobby case and saying you're going to pay for this abortion-inducing drug. So yes, I mean, we are going to continue to see bits and pieces of this issue because unfortunately, the consensus that we enjoyed for so long on the left and the right, that the freedom of conscience needs to be sacrosanct, it needs to be protected, that has dissolved. And so there are people on the other side. We had a debate about health care recently and about doctors being mandated to perform abortions. And the person I was debating actually said, well, if they didn't want to do that, they shouldn't have gone to medical school. But that's the mindset that we are contending with. Yes, sir.
Along that same line, for years, we had a situation where someone driving a vehicle hits a car, child murdered in the car. Now we turn around and say, abortion is not up for murder.
Well, and there's a further conflict in the law in that prosecutors can charge if there's a murder of a pregnant woman, the prosecutor can charge 2 counts, for the child. So there are numerous inconsistencies in the law on that subject.
What is happening in our public schools? We have situations where a teacher can't put a Bible on their desk. The Muslims talk about that sort of thing. Or we have situations where the Muslims want to have a place to have prayer, but they don't want the Christians to do that. And also we have situations where the Muslims do physical harm under our laws to their members who do certain things, like a daughter that might have dated a Christian or something like that. We've got to address those things because this is just tearing up our philosophy.
No, absolutely. And to your point about people trying to violate the criminal laws and then claim a religious sort of defense, that was something that was sort of thrown in our direction about this bill. Oh, you're going to enable child abuse because somebody will say, well, spare the rod, spoil the child. I'm going to discipline my child however I see fit, and the state can't do anything about it. It is always in the state's compelling interest to enforce the criminal laws and to protect the welfare of children. And so any case you see in the nation where somebody has tried to assert a religious freedom defense, I don't care what state they're in, to the violation of a criminal statute, they lose every time because the state clearly has a compelling interest, particularly when it comes to protecting the welfare of children. Yes, sir.
Well, I was going to ask, a couple weeks ago I read an article about a very big food company giving the Muslims in there all day long, their own little prayer room. The Christians asked for the same treatments where they could go pray, and the union said no, and Dyson said no also. Why hasn't that been more out there? They're getting their freedom, but they're cutting away ours.
Well, and again, that's why it's so important to have a fundamental legal principle out there that says everybody gets accommodated. You know, if you leave it in the hands of, you know, a private party to decide, then they can do things like that. They can say, well, we're going to give this group an accommodation, but not this group an accommodation. We need to make sure that the law everywhere is very clear that if you're going to provide an accommodation for one, you're going to provide an accommodation for everyone. And again, that's why I think having the legal standard raised is so important. Now, religious freedom is going to be enjoyed by everybody, whether I agree with their religious point of view or not, but it ought to be equally enjoyed. And so that's something we've got to work on. Yes, sir.
Just a comment on those lines about the prayer and coach out in Washington. Have you ever seen when one of Joe Gibbs' drivers went to a NASCAR race?
Yes, sir.
It's pretty, and I don't think you're going to tell Gibbs you can't do that.
No, sir. No, sir. Absolutely not.
If the camera doesn't pan off on a football infield out in the middle after a game, you'll see them down there kneeling in prayer, and then all of a sudden the camera gets away from them.
Yes, sir.
Josh, having dealt business-wise in a situation with Kevin, I believe he's leaning more towards big business than Deal ever did. What's your stance, given the fact that you're going to go for lieutenant governor? Who are you supporting for governor?
Well, what I want to say to you is this about the governor's race. I think that you're going to see in the next couple of weeks, I think every candidate for governor is going to be given the opportunity to sign a pledge, to make it clear, not just I'll sign the bill if it gets to my desk, because there are all kinds of games that get played with that, but am I going to forcefully advocate to protect the religious freedom of all Georgians? Am I going to do that if I'm elected governor? And it's going to be pretty specific. It's going to be hard for somebody to try to, you know, slip around it. So what I would urge everyone to do is follow very closely how people respond to that. I think some candidates are going to sign it. I'm pretty sure some candidates aren't going to sign it. And I would just, you know, I would follow that. If this issue matters to you, that's the question. And these people are going to be in your community. I mean, every single one of them is going to come through here. And I would say, if there's any way for you to be in that room and put that question to them, say, you know, I was at breakfast with Josh McKoon, and we spent a couple of hours talking about religious freedom, and we don't understand why it's taken, you know, 4 years or 5 years to get the job done on this. Are you going to make sure in 2019, when you're governor, that this bill becomes law? Are you going to do that? Are you going to make that commitment to me today? And if you get an answer that's other than yes or no, you kind of have your answer, you know.
Can a politician answer a question yes or no? I've seen that.
But thank you very much. Thank y'all very much. I appreciate it.